So let's talk about arbitration procedures. Oftentimes the procedures begin with pre-hearing activities. Again, we already talked earlier in class about selecting arbitrators and different types of arbitrators. But at the beginning of the procedures, there's often pre-hearing activities, including pre-hearing stipulations. These are a summary of what the arbitrator is likely to face in the arbitration process. And they sometimes are very brief, like an executive summary. Other times they are very lengthy. These are not very common, but again, are a way of expediting the process by identifying some jointly agreed upon facts. So the arbitration hearing average 1 day in length, but a hearing can range anywhere from a few hours and could be as long as a few days. The arbitration hearing takes on different kinds of formats. And so in the legalistic approach, there is generally more of a definitive winner and a definitive loser. There is an insistence that there be a specific level of proof identified at the beginning of the hearing that is used to make the decisions. That could be a preponderance of the evidence. It could be evidence beyond a reasonable doubt. Whatever that is, that's specified in advance under the legalistic approach. Also, the legalistic approach tends to have more of an adversarial approach to cross-examining witnesses, where the supporters of one side will try and undermine witnesses for the opposition. Now, the problem-solving approach addresses the fact that both parties have a mutual obligation to bring out all relevant facts. So it's a little less adversarial. There is a stipulation of certain facts that both sides agree upon. So again, there doesn't have to be as much fighting over the different facts. Cross-examination tends to be less threatening, and there tends to be generally just less adversarial behavior and more friendly and dignified behavior towards the other side. Now, continuing on the arbitration process, there is a certain general order of business to the arbitration hearing. It usually starts out with an introduction of joint exhibits. These are typically things like the collective bargaining agreement that is relevant to the case. It includes copies of the original grievance and any written responses to that grievance. And it also identifies exhibits where there are facts that are not in contention, agreement about different facts. After that, there is a framing of the issue, and this usually initiates with the parties and the grievance trying to frame the issue, and that involves putting the issue into a one-sentence question that is going to be answered by the arbitrator. Now, if the sides cannot frame the issue, oftentimes the arbitrator will attempt to frame the issue in a way that is acceptable to both sides. After that, there is a presentation of the exhibits. This is like in a trial, the process of discovery. So things that are going to be used as evidence have to be brought forth by the company, by the union in advance, so there can't be these surprises along the way in an arbitration hearing. After that, there are opening statements, and the spokesperson for each side will identify what they intend to prove and highlight the major issues. After that, there is testimony and cross-examination of witnesses. And finally, there is a summary and closing statements, or sometimes there are post-hearing briefs instead of closing oral statements. Now, in about a little less than half, about 46% of the cases, do agree for a written transcript. This can be used as a reference in closing statements, can be useful for making decisions. Now, again, we said that in lieu of oral statements at the end, sometimes there are post-hearing briefs. And these are written summaries at the end of a brief. And these include a statement of the facts, a citation of the relevant information from the contract, arguments made in support of the party's position, arguments countering the positions made by the opposition. It also includes the request for a specific decision from the arbitrator. Now, there is some evidence discussed in your book that these post-hearing briefs really don't make much difference. So one very experienced arbitrator said that in 95% of the cases, post-hearing briefs make no difference in the arbitrator's decision. And this is interesting because, again, these are being used more and more often, but they tend to slow down the proceedings. They also tend to add cost because it takes more time for the arbitrator to review these post-hearing briefs. And this really undermines advantages of arbitration, that arbitration is cheap and it's fast. So this trend to use post-hearing briefs is really kind of counterproductive. So let's talk about the arbitrator's decision. And there are different elements to the arbitrator's decision from a classic point of view. And so usually it includes the names of the union and the management representatives involved in the case, along with anybody who gave testimony. It usually includes the statement of the issues, a statement of the facts surrounding the grievance. It provides the pertinent provisions in the labor contract. It includes a summary of the union and management positions. It also includes an analysis of the evidence and analysis of the arguments in relation to the contract language. And then finally, it includes the arbitrator's decision, whether the grievance is upheld, whether the grievance is denied, or whether there is some kind of compromise decision that is made between the union and the management positions. So there are a number of criteria that arbitrators use in making their decisions. So these include, who has the burden of proof? Is it the employee's role to have the burden of proof, or is it the employer? Arbitrators will also look at the credibility of witnesses and how that was influenced by the cross-examination process. They will be looking at the labor agreement and whether there is clear and unambiguous language that in that labor agreement, or whether there is some need for interpretation of that. The arbitrator will look at what the intent was of the parties. So there is kind of an inference made about the motivation. There will also be some look at past practices. So is there a pattern that's taken place that serves as a precedent? And they'll look at previous arbitration awards and principles of arbitration. Now, there are some things that can be done to expedite arbitration procedures. And again, one of the advantages of arbitration is that it's supposed to be fast. And so one thing that can be done is to expedite the pre-hearing procedures. This can be done by having a panel of arbitrators that are already agreed to, or having a permanent arbitrator, a permanent umpire. Again, in larger unions where arbitration is more common, these may be very important ways of expediting the arbitration process. In smaller unions, you're going to use more of an ad hoc process, and having more permanent arbitrators or a panel of arbitrators will be impractical. There can also be things done to expedite the process in the post-hearing procedures, such as setting a deadline for the return of an award, or reducing or eliminating the number of citings in a case, or setting a maximum for the length of the award statements. So setting a word length limit on the statements. And then there can also be a maximum for the paid decision that is established, and again, that can expedite the process.